There continued to be new developments in the death of Breonna Taylor. Now, following the outrageous grand jury decision not to bring any charges against the officers who killed the 26-year-old woman during this alleged no-knock raid on her apartment, which culminated, of course, in a gunfight between plainclothes officers and Kenneth Walker, a Kentucky judge has just ordered the release of audio recordings from the grand jury hearing itself on the Breonna Taylor case. So now this is interesting. Now, the decision by a Jefferson County Circuit Court judge came after an anonymous member of the grand jury had filed a motion asking that the transcripts and the recordings of the 3-day hearing be released. Now, normally, of course, grand juries are kept secretive, but there was somebody that had been a juror that was so outraged by the result that they had to go public and ask for these recordings, for this information to be out there. So that, again, is super, super interesting about this. Now, according to the grand juror's attorney, Kevin Glaugower, the client, the person is quote-unquote aggrieved that what was presented is not being disclosed publicly. Mainly, I would think because the grand jury is getting a lot of heat for Breonna Taylor not getting any sort of justice at all. But now, Glaugower said, I think the grand jurors were aware there were certain questions that were left unanswered. It's the accountability and the sense of public trust to make sure that everything that can get out of there does, and there was some concern that maybe it wasn't. Okay, so what are they talking about? Well, apparently there was some charges and evidence that might have been missing. See, a grand jury can only see evidence and only get charges that's presented by the Attorney General and to make decisions on the charges. So now the Attorney General, in this case, happens to be a man named Daniel Cameron. Daniel Cameron is a protege of Republican Mitch McConnell. Now, it doesn't matter that Daniel Cameron is black because you can be black and still be taping for the establishment, for white supremacy, and all that stuff. And so I don't know if that's the case, but it sure seems like it in when you look at some of this. Now, he admitted just recently in a sit-down interview with a local news station that he admitted that he didn't bring murder charges to the grand jury. So now, if he doesn't bring the murder charges to the grand jury to deliberate on, then the grand jury obviously cannot, make a decision on whether or not they will indict them on those murder charges. So that, again, that is really, really important. So now, he said that the office found murder charges as not appropriate. Quote, our recommendation was that Officers Jonathan Mattingly and Miles Cosgrove were justified in their acts and their conduct. Those are the two officers that between them had shot Breonna Taylor 6 times. Now, the only person that was punished was Hankinson, who actually arrived late and started shooting into the apartment 10 times. And so that was the only person that was indicted, and that was for wanton discharge of a weapon. And so, and not just into Breonna Taylor's apartment, but damaging possibly another person's apartment as well and putting other people in danger. So that's what the only charge. Now, the only charge that the grand jury, as I said, decided to agree upon is wanton endangerment. For Hankinson, Hankinson, of course, was fired as a result of that. So now, there's a lot of disinformation going around about the case, especially from the right wing. So understand, here are some of the basic facts, okay? Now, the officers were serving a search warrant on Taylor's apartment in the early morning hours of March 13th. It wasn't actually a no-knock raid. Originally, it was, but then at first, it was a no-knock, but then they had changed it to where the officers were encouraged to announce themselves. Now, the officers say, well, yeah, we did, and they didn't do anything. So then we busted in, and we were shot at. But we announced ourselves, so they were shooting at a police officer, which means we were justified in self-defense. That's what they were saying. Now, the reason for that raid was that they were looking for evidence of drug trafficking in her apartment. Now, there was no evidence of that. They didn't find any drugs. They didn't find any of that. Okay? Now, furthermore, that this warrant was based on a sworn affidavit from a detective that alleged that an ex-boyfriend of Taylor's was using her apartment for drug trafficking and was sending packages through the U.S. mail. Now, keep that in mind. There was no evidence of any mail packages being sent full of drugs. The warrant required the police to verify with postal inspectors that the ex-boyfriend was receiving packages, but according to lawyers for Taylor's family, the Louisville postal inspector denied that his office inspected packages sent to Taylor's home as part of that investigation. So there is, of course, one thing that doesn't seem to add up. Furthermore, the LPD tried to pressure the ex-boyfriend, which they had in custody, into implicating her in the scheme after her death, post-mortem. So they shoot her, kill her in this botched raid. They don't find any drugs. They don't find any evidence. And so they go to the ex-boyfriend, who they already had in custody, and say, hey, can you implicate your ex-girlfriend as part of your drug trafficking ring? And he wouldn't do it. He wouldn't do it because it wasn't true. And so understand what they tried to do. They tried to smear her endlessly. Now, that said, the Attorney General did not present the options, despite all the stuff that happened. They didn't present the options for homicide charges at all. That is absolutely outrageous. Outrageous. And as a lot of you point out, and I totally agree with this, even if there was drugs in this house, that doesn't mean that cops should be judge, jury, and execution. You shouldn't be killed for drugs. In fact, I believe at least in drug decriminalization. Because if there weren't a drug war, this wouldn't have happened. And understand, too, that the allegations that this could be, this entire thing could be a result of, for example, trying to gentrify the neighborhood and to get these people out, to get the minorities and poor black folks out. Well, that's another thing as well. And so, anyway, as far as, again, Breonna Taylor's concerned, she absolutely was a victim. She was caught between plainclothes police officers that were breaking into her apartment in the middle of the morning, causing her boyfriend, who was a legal gun owner, somebody who had no criminal record whatsoever, to fire in self-defense. But there's even questions about whether or not Kenneth Walker even hit one of the officers, Officer Mattingly. They don't even know. But we'll get to that. Breonna Taylor was caught in the middle of this. Now, attorneys for the Taylor family released a statement on Tuesday as a result of this, saying that Daniel Cameron clearly failed to present a comprehensive case that supported justice for Breonna. Quote, that conclusion is supported by the grand juror who came forward to say that the Attorney General misrepresented the grand jury's deliberations. We fully support the call to release the entire proceeding transcript as the only way to know what evidence was presented and how the grand jury instructions led to this outcome. Again, all led by Daniel Cameron. The attorneys also alleged that prosecutors presented scant evidence, if any, that pertained to Taylor's death, and cited at least 11 witnesses who dispute Cameron's claim that the investigation showed the officers knocked on the door and announced themselves before using a battering ram to force the door open. So, that again, you hear that, the cops, they announced themselves. And so, I mean, it's Kenneth Walker's fault that he shot at a cop. But wait, they didn't announce themselves, and you have a lot of witnesses that say they didn't announce themselves, that they didn't hear anything in this apartment complex. Well, then, that means that Kenneth Walker was justified in firing what he says was a warning shot. Not at an officer, but a warning shot at these plainclothes thugs that broke down her door with a battering ram. 11 witnesses. Now, Walker's attorneys say one witness, by the way, and this is the one Republicans, right-wingers always seem to cite, is, there's a witness that they did identify themselves. Walker says those witnesses, his attorneys, by the way, say that witness changed the story. They told ABC News that a week after the shooting, the individual claimed the officers did not identify themselves as police, and yet 2 months later, he said that they did. Vice News published an alleged recording of the witness, telling an investigator that on March 21st that, quote, nobody identified themselves. ABC News has not independently verified that audio, but it does exist. And so, even so, if you have 10 witnesses that said they didn't identify themselves and one that says, maybe they did. I mean, they didn't, but then I think maybe they did. Well, then I would tend to believe the other 10 people when they say, no, we didn't hear them identify themselves at all. Now, Jefferson County Circuit Court Judge Ann Bailey Smith ordered that recording from the grand jury hearing be placed into the court record by noon on Wednesday, so today, despite objections from Daniel Cameron, who said he will comply with the order. Oh, well, at least he's not like, for example, Wilbur Ross, who just ignores court orders, and the Trump administration itself, who just ignore court orders at all. The judge's decision, they said, was not based on the grand juror's motion, since they said that Judge Smith ordered the recording as part of the normal trial rules of discovery. And so, look, let's get back to Mattingly, right? Again, right-wingers, like people like Charlie Kirk, are like, I can't believe Kenneth Walker would shoot these officers, therefore making the justification for these officers to return fire, to which, unfortunately, Breonna Taylor was caught in the middle. And so they're saying it's all Kenneth Walker's fault for shooting at cops and then hitting Mattingly in the leg, allegedly. However, you look at this, some of the evidence that may have not admitted to the court, and this is from the ballistics report from the Kentucky State Police. They could not determine that Walker was the one who shot Mattingly. They just didn't know. Quote, a portion of the Kentucky State Police ballistic report obtained by ABC News indicates that one shot fired by Walker was neither identified nor eliminated as having been fired from his weapon due to limited markings of comparative value. Walker claimed that he had fired a warning shot because he initially thought the police were intruders. The civil suit also raises the possibility that Mattingly was wounded by friendly fire from one of the officers. So it could have been one of the officers accidentally shooting Mattingly within the entire, like, clusterfuck which happened at that point. Look, it's amazing. So there obviously needs to be a release of this information and these court records, because something does not add up here. And it all seems to point to Daniel Cameron and his relationship, of course, with the police, his identification as a political conservative, and his apparently refusal to want to really find the facts in the case. So, I don't know. It seems like he's got something to, maybe not to hide, but doesn't really seem to be interested in justice for Breonna Taylor, which is super unfortunate because, look, as a black man, he should probably be aware that Republicans generally don't give a shit about him. White supremacists, they don't give a shit about him. They don't. You think they're not going to come for him after they're done with everybody else? Yeah, exactly. If you enjoyed this video, please give us a like and share with your friends. You can subscribe and help out the channel by becoming a patron. It's patreon.com/Jeff Waldorf, or you can become a channel member as well by hitting the join button below.